Mr. Stockard, would you please state your name for the record?
Sure, my name is Dusty Stockard.
Mr. Stockard, would you tell the jury what it is you do for a living?
I'm an investigator for the Travis County District Attorney's Office.
How long have you done that?
I've been doing that for 5 years.
And what does that entail?
That entails taking charge of a crime scene. I lead the crime scene investigation and the team there. So I basically direct the scene.
What sort of crimes do you have experience investigating?
So I've investigated 40 homicides in the past 5 years.
Mr. Stockard, did there come a time when you became involved in the investigation of the death of somebody who later became known to you as Stephen Walker?
Yes, I think it was when I got a call at 1:37 a.m. on Saturday, May 14th, 2011.
Would you describe how you became involved in that investigation?
Sure, I received the call. I was told that there was an apparent homicide at the Remington apartment complex in Armadillo. So I went over there, found Mr. Walker's apartment, and I found his body lying in his apartment.
Would you tell the members of the jury what, if anything, you did after you found his body?
Well, I observed that he had been shot twice in the chest, once in the head, and the bullet wounds appeared to be made by a small caliber pistol.
Objection and proper opinion.
Sustained.
Move to strike.
Move to strike. Stricken.
Your Honor, just to clarify, the
Okay.
striking is just the small caliber reference.
Striking is the opinion. Yeah, small caliber pistol. If you want to further
Yes.
Vordier, your witness's expertise on.
You indicated earlier you investigated 40 homicides. How many, if any, of those have involved gunshot wounds?
Almost all of them.
And how did the gunshot wounds that you saw here compare to other ones you've seen in the past?
They looked consistently similar.
What, if anything else, did you find in the vicinity of the body?
I found a shell case, a .38 caliber pistol shell casing.
Objection and proper opinion.
Sustained.
Move to strike the portion referring to the side of the caliber.
Yes, or you're not allowed to consider the size of the gun or the bullet.
After you found the shell casing, what, if anything, did you do next?
So I just did an investigation of the apartment. We looked at the door. The door hadn't been forced open. And we also examined Mr. Walker's laptop in his bedroom.
What, if anything, did you find on that laptop?
Well, on that laptop, I was able to access his social media accounts, specifically his Twitter account.
May the record reflect I'm approaching opposing counsel with what's been marked for identification as State's Exhibit 1. Your Honor, you'll find this in the record at page 30, marked as Exhibit 1. May I approach the witness?
Yes, you may.
Mr. Stockard, do you recognize what I've just handed you?
Yes, I do.
What do you recognize it to be?
This is the Twitter page, Mr. Walker's Twitter page, as I saw it on his laptop on the day of the crime.
Without getting into the actual contents, how do you recognize it to be that Twitter page?
Well, I recognize Mr. Walker's Twitter handle as well as the Twitter handle of the person he was talking with on the day of the crime.
Is this a fair and accurate representation of the screen as you saw it that day?
Yes, it is.
All right, I move for the admission of State's Exhibit 1, the Twitter page.
Your Honor, defense objects to rapid hearsay in 403.
Your Honor, as may be heard. Fourth.
I'm going to take a look at the rules real quick. Rule 403 counsel?
Yes, sir.
Let me hear you.
There is a certain inflammatory language contained within these Twitter messages, specifically those purporting to come from Sally Dratt, in which she says that my father would kill me if he found out. We find that this is an inflammatory language that could lead to improper inferences by the jury, in which this is the danger of unfair prejudice would substantially outweigh any probative value of such statements.
So your concern is just the being prejudiced over value?
In addition to the fact that it is hearsay, Your Honor.
As a hearsay, Your Honor, this isn't being offered for the truth of any matter asserted within, but rather for the effect it had on the reader of the investigation. Here, we anticipate that Mr. Stocker will testify based on what he saw here. He called the defendant John Draft because he saw Sally Draft in the Twitter message, and so he made the link and decided to call somebody who he knew to be her father, John Draft.
So you were saying this is basically a piece of the puzzle for investigation purposes?
That's correct, Your Honor. So it's not offered to prove any truth of anything said within, but rather to show what he did afterwards. Your Honor, for that same essential reason, we would argue that this does not violate Rule 403. This is not going to inflame anybody's passions based on a statement that a teenager makes. My father would kill me. Teenagers all the time make statements. My father would kill me if he saw me with his car. My father, it's, just a colloquialism, Your Honor.
Your Honor, may I be heard?
Sure.
Under normal circumstances, that may be the case. However, we are dealing with a murder trial. Inflammatory language in that regard can lead to substantial unfair preferences by the jury, and as such will unfairly prejudice the defendant.
How about we let it in for purposes of fitting the puzzle for Mr. Stocker here to have it led to a potential suspect, but move to strike any verbiage or wordage for the jury to hear. The move to strike the actual language in the Twitter.
So to redact the inflammatory language?
Correct.
That would be acceptable for the defense, Your Honor.
Your Honor, look. We'll cover the language about my father will kill me.
Okay, I move jury. You're not allowed to consider what the actual.
It's actually been redacted.
Okay. So,
Permission to publish the redacted documents to jury.
yeah, fine. Yeah, counsel.
Mr. Stockard, would you describe for the jury what that is?
Sure, that's Mr. Walker's Twitter account, specifically the page that shows him exchanging Twitter messages with Mr. Walker's daughter. Mr. Draft's daughter.
When you saw this Twitter page, what, if anything, did you do afterwards?
After seeing this Twitter message, we identified Mr. Walker's age, and then I called Mr. Draft to determine his daughter's age.
How did you know Mr. Draft's number?
Well, I have been dating Mr. Draft's wife, Pam.
How, if at all, did that relationship affect your investigation?
Not at all.
When you called Mr. Draft, would you describe for the jury that conversation?
Sure.
Sorry, counsel. You were dating who, sir?
The defendant's wife, ex-wife.
Okay, thank you.
Would you describe for the members of the jury the conversation that you had when you called Mr. Draft?
Sure. I called Mr. Draft. I asked him how old his daughter was. He told me she was 17. And then I told him that Mr. Walker had been killed. And the first thing he said was, I didn't do that.
Mr. Stockard, do you recognize Mr. Draft here in the courtroom today?
Yes, I do.
Would you point him out for the record based on where he's sitting and something he's wearing?
Sitting over there, wearing glasses, dark glasses.
After you called Mr. Draft, what, if anything, did you do next?
Well, after speaking with Mr. Draft, we executed a search warrant on his house to discover any small caliber firearms.
And what, if anything, did you find inside his home?
Inside his home, we found a receipt for 32 caliber ammunition.
Objection, witness testifying as to the contents of the document that is not admitted into evidence.
Your Honor, the witness is just describing what he saw.
You have a rule, counsel?
Yes, Your Honor, the objection would be hearsay.
Okay. To a document that he's,
To the contents of a receipt describing the item purchased. The witness is testifying as to that document which has not been admitted into evidence.
so counsel, do you have a copy that you can show?
We do, Your Honor. Actually, the record will reflect an approaching opposing counsel with what's been marked for identification.